Good evening. This is Rahul Reddy, live from Houston, Texas. Reddy Neumann PC brings live immigration updates every week on Tuesday at 5 p.m. Along with me is my business partner, Emily Neumann. Emily, what do you have today?
Thanks for joining us today. I want to discuss the cap gap. Now that we're getting close to the new H-1B pre-registration lottery system on March 1st, there's not a lot of information out there about how the cap gap works this year, and it is going to be different than what it's been in the past. So we want to make sure everyone's aware of that and guide you so that you can timely file your H-1B if it's selected in the lottery to take advantage of the cap gap. We also have been seeing the visa reciprocity tables being updated by the Department of State quite a bit in the month of January of 2020 already. So what is visa reciprocity? I'll be explaining that and tell you what changes we've seen most recently that specifically impact Indian citizens. And we also had an update in the February visa bulletin, which came out recently. In the notes towards the bottom, it talks about predictions for EB3, the rest of world category, so we want to make sure you're aware of that. We've been seeing lots of details going around about the green card interviews. So when you're called into your local office to attend your interview, when you're close to the end of the process, more and more questions have been asked very recently about marijuana use. So we want to make sure that you're aware of that potential for that question to be asked so that you can discuss with your attorney and be properly prepared.
Emily, on the electronic registration, we do know that the electronic registration is available from March 1st to March 20th. They may change the dates a little bit, or they're not going to change the dates?
The end date might go longer. It wouldn't go shorter, but it could potentially. I don't think it will, but it potentially could.
So most probably it'll be between March 1st and March 20th. At this point of time, we don't have the URL where the employers can register and make the information available. You know, our audience already know that the employer has to register, they have to fill in their the employer basic information, and they need to give the information of the employee, the basic information, date of birth, whether or not they're going to apply in the master's quota or bachelor's quota, and their full name. And Emily, on this registration process, on the cap gap, you said you have some updates on it. What exactly is a cap gap? Can you explain? And what should people be very careful in this new quota system as compared to the last time?
Yeah, so this is specifically for F1 students with OPT that are transitioning to H-1B. The H-1B will not start until October 1st at the very earliest. And so for F1 students whose OPT is ending before October 1st, it created a gap in employment authorization. This is what we refer to as the cap gap. It's the H-1B cap causes a gap in your employment authorization because the H-1B cannot start until October 1st. Now we have a special regulation for those that file the H-1B requesting a change of status with an October 1st start date. Your OPT may be extended automatically to September 30th pursuant to these cap gap provisions so that you can continue working without interruption from the time your OPT ends to the time the H-1B kicks in on October 1st. That's how it's supposed to work in a perfect world. Everybody knew in the past years, you filed your H-1B on April 1st. It took sometimes several months to find out whether you were selected or not, so you had to go back to your school, find out if your SEVIS record has been updated to show that there's a change of status pending, and then they would give you that cap gap I-20, which proves that you have the extended work authorization. Well, now we'll know before even April 1st whether you've been selected in the lottery. What this means is this is very important for anyone whose OPT expires between April 1st and June 30th. If your OPT is expiring before June 30th, we've been telling you you have until June 30th to file your H-1B in the lottery once you've been selected in this new electronic registration system. But if your OPT expires before June 30th, you actually need to make sure your H-1B gets filed earlier than that. Even though the regulation allows the H-1B to be filed up to June 30th, you have that 90-day filing window. If your OPT expires before June 30th and you need that cap gap, you have to file the H-1B before your OPT ends. So for example, say that your OPT is set to expire on May 15th. On March 31st, you find out you were selected. Your employer must file your H-1B by May 15th. Even though everyone says you have till June 30th, for you, you have to file by May 15th so that you can get the cap gap extension. And you have to request a change of status. The start date has to be October 1st that your employer is requesting for you to qualify. So be very aware of that, because a lot of people, I think, are unaware that you have a shortened time period to file if you're going to need the cap gap.
Yeah. Emily, on the visa reciprocity, this is what the State Department has issued. Any updates on what's going on?
Yeah, so visa reciprocity is on the State Department's website. Basically, it's a list of every single country, and if you are obtaining a U.S. visa and you're from that country, it will tell you how long your visa should be given for, and it will tell you whether you're subject to any extra visa fees called the visa reciprocity fee. These tables are set based on how other countries treat U.S. citizens if they were to apply for a visa to go to that country. So these get updated from time to time. It's one of the things the Trump administration has mentioned from the very beginning, that they want to make sure that we're treating other countries the same way that they're treating us. And so we've been seeing a lot of revisions in the visa reciprocity tables. Most recently, just last week, they updated it for Indian citizens. H1, H4, L1, and L2 visa stamps can be issued only for a maximum of 35 months.
Well, wait, we get H-1B for 3 years. They only give for 35 months?
Exactly. So your petition might be approved for 3 years, but when you apply for the visa stamp, you're going to get 1 month less. And again, that it makes not a lot of sense, because
But what happens when I come into United States, though? Will I get 36 months or 35 months?
Yeah, so when you come into the United States, assuming your visa has not expired, you would get the time period that's on your approved petition, the whole 36 months. Unless you're coming in during the 36th month, then you don't have a valid visa.
Then you can't even come in.
Then you can't come in. So it seems a little silly that someone would need to renew their visa for that last month. So maybe not a huge impact, but these tables have been updated a lot. There are a lot of other countries, not necessarily things that we talk about a lot on here in terms of H's and L's and TN's and that sort of thing, but for many other countries and for different types of visas that we don't necessarily talk about a lot, they are getting updated quite a bit.
This seems to be very confusing. Seems to be that the State Department wants to make some jobs out of themselves. They should be running the visa things according to what they feel is better rather than what the other country is doing. Especially, monitoring all the 190 other countries. It's just a bureaucratic system that they have created, Emily. On the EB3 visa priority dates, Emily, we know that it's backlog for Indian nationals, Chinese nationals, and recently Philippine nations and also Mexican nationals. What's going on the rest of the world right now?
Yeah, so EB3 rest of world has been current for some time, but that category has seen a dramatic increase in the number of people filing the adjustment of status here with USCIS. Which makes it difficult for the State Department to figure out how many people are in the pipeline. They're more used to dealing with consular processing cases, so they know exactly how many I-130s are in the pipeline for consular processing or how many I-140s are in the pipeline. They don't necessarily see how many people are planning to file adjustment of status, and the number of adjustment of status filings for EB3 rest of the world, the demand has really increased. So in the February 2020 visa bulletin that came out last week, there's a note towards the bottom warning people of likely retrogression in EB3 rest of world for the March 2020 visa bulletin. So that means EB3 rest of world might not be current in March. So if you're current in February, make sure that you file by the end of the month your 485, because you may not have the opportunity to file it in March.
Emily, marijuana use is legal in some of the states. It's not legal in some of the states. So, what's the problem with the immigration? Let's say, for example, I know that Colorado it might be legal. I don't know. I'm not a Colorado lawyer, but if it's legal in Colorado, if they smoke marijuana, is that going to cause a problem with immigration?
Absolutely. Basically, even if it's legal in all 50 states, it is not legal for immigrants or non-immigrants.
Well, let me first go and explain though. There are two jurisdictions here. One is the state jurisdiction, one is the federal jurisdiction. It may be legal in some states, but marijuana is not legal according to the federal government. According to the United States government, it's not legal. Then you may ask the question, if when people smoke marijuana in Colorado or some states where it might be legal, why isn't the United States government doing something? They may or may not enforce the law. It's up to their discretion to enforce the law. That doesn't make it legal for people to smoke marijuana according to the federal law. The state law might be allowing it, but not the federal law. Now, when it comes to the immigrants, though, it's different. The federal law will be enforced at the time when you go for the green card. We have had a lot of questions, people that, can I invest in marijuana stock as an immigrant? The answer is no. We are not advising the US citizens on this particular matter. Please take an advice of your criminal lawyer or somebody else. But when it comes to the non-immigrant visa people and also for the green card holders too, please listen to us very carefully these things, that marijuana is not legal in United States. Though in some of the states they say it's legal, as far as the US law is concerned, it's not legal. Emily, what questions would they ask when they go for the green card interview?
Yeah, we've seen kind of some they're actually having a sworn statement filled out and signed at some of these interviews. So they're very detailed, going through, explaining to you what are the elements of what's considered marijuana use under immigration law, explaining those to you, and then asking very specifically, have you done this? Have you done that? Was the amount this? Did you have a prescription? To make sure that whatever use you had was, to make it clear that it was not
Can they not take the
legal.
Fifth Amendment, Emily?
Well, I suppose you could, but you're not going to get your green card. I mean, you have to answer the question, and you have to answer it honestly. You can't make a misrepresentation during your green card interview. They're going to have you sign this.
How would they come
statement.
to know?
It doesn't matter. I would say don't risk it.
As Snowden said that, I'll go back to this. What Snowden said is that even if your phone is powered off, they are recording it. So if you're under the belief that the government is not seeing it, well, you should not be watching these videos, because look, everything is out right now. The government is watching anything and everything. So please don't go near marijuana, don't smoke, don't do anything. If you are a US citizen, though, you can take the advice of somebody else, not mine, not Emily's. That's up to you. Other lawyer who can advise. As far as the immigration lawyers is concerned, as far as I and Emily is concerned, no, you cannot smoke. And if by any chance you do it, we would recommend that you contact an immigration lawyer.
Yeah, and it's not even just smoking, it's possession of it. It's working anywhere related to that field. There are some legitimate jobs. We've even seen IT, like software engineers, who were placed on a project for a state government that was putting together some sort of marijuana something or other database, and USCIS said, no, you can't do that. Anything, even if it's the most remote connection to anything marijuana, stay away from it. Be safe.
Be safe. And consult an immigration lawyer if you have ever. Even if you have invested in any of the stocks or marijuana, please consult an immigration lawyer. Now, let's go to question and answers. One question that comes out is that this gentleman from YouTube has went to visa stamping for H-1B. He got a 221G, he's yet waiting for the decision. Can he work sitting down in India while he's waiting for the 221G? Yes, you can. Here is the reason how you can work even though you didn't got the H-1B stamping. You're an Indian national. You can sit down in India and work. You have a work permit in India. So, I mean, you're an Indian national. You automatically have a work permit in India. So you can work. Oh, by the way, I'm also a licensed lawyer in India and United States. Since you're Indian, you can sit down in India and work. Absolutely no problem. US has no problem. The immigration has no problem because you're working remotely. They don't consider as that you're working in United States. They consider that you're working in India and you're perfectly legal to work in India.
All right. Ashikar from Facebook is a Canadian citizen and wants to know how he can get a green card in the United States. Well, there really are no special provisions for Canadian citizens, and it does boil down to what your country of birth is. So if you were not born in Canada and later obtained Canadian citizenship, that does not provide you any benefit in the green card process. You're still going to be under the chargeability category of your country of birth. So there's no special provisions that allow Canadians anything for a green card. It's either through the family-based categories, immediate relative, spouse of a U.S. citizen, parent of a U.S. citizen.
Well, Emily, you said that if he is not born in Canada, he can't avail the faster green card process because of the rest of the world because he's born. Is it the same thing with TN visa or can you get a TN visa?
Yeah, that's a great question. The Canadian citizenship does make you eligible for the TN visa as well as for e-visas. But on the green card side, it's still based on your country of birth. Now, of course, if you are born in Canada, then you do get the somewhat faster processing of being in the rest of world category, but you still have to fit under one of the family-based categories or one of the employment-based EB1, EB2, EB3 with the perm process category. So nothing special there.
Reddy has this question from YouTube. His visa is expiring in September of 2019. Now he's in India. His employer got changed. Is he eligible for Dropbox? I'm not sure. When you say employer got changed, I'm assuming that if your employer got changed, you are supposed to get a new H-1B approval before you come into United States. So if you got the employer change, you can get a H-1B approval with the new employer. And you don't even have to go for stamping because your stamping is available until September of 2019. You can just enter into with the stamping of company A, with the approval of company B. But when you enter into the United States, please mention to the CBP officer that you're going to be working with company B, not with company A. Rengan has this question on the L1A. What's the approval rate on L1A? Emily?
So, great question, and we actually had brand new data that was put out just this week from USCIS. It's on their website. Off the top of my head, I apologize, I can't remember what the numbers are, but if you follow me on Twitter, either yesterday or the day before, I had several tweets where I went through the specific provisions and what the approval rates are, what they were on average from 2015 through 2018 and what they dropped to in 2019. There's definitely a difference for L1s.
One thing I would suggest you, Mr. Engan, is that from Facebook is that try to get the results of the L1A extension before your I-94 expires. That would be the best thing you can do. Because if you by any chance get a denial, you have another opportunity to file an extension even though you got the denial. That is the biggest mistake we have seen that a lot of companies do is that they file in the normal processing and they take a long time. You get a denial, you'll be forced to leave the country. Then the question pops up is that I got a denial with the same job. Can I get approval with the same job? Yes, we have seen several times that the same job which got denied now goes back to the USCIS and they approve it. Sometimes what happens is that, depending on how the immigration is acting upon your job, the lawyer may be able to correct it in a better fashion, to present it in a better way. And maybe, the company might want to change some of the job duties that were existing because you got the denial right now. There is no hope to get the approval. Maybe they want to change some of the job duties. that might be another reason too. We have seen several times that the denial with the same or similar job, again when you go back to the USCIS with some slight changes, got their L1s approved, and in some cases H1s approved too.
Lokesh Reddy from YouTube wants to know if an H-1B transfer or extension is denied, what is the time duration you have to leave the country, and when can a new H-1B be filed? So of course it depends on the specifics of the situation. If your I-94 has already expired at the time of the denial, that is where you have to be very familiar with the 180-day clock for unlawful presence. So when you file an extension, that extension keeps you in a period of authorized stay, even if your I-94 expires. But if that extension is ultimately denied after your I-94 expires, you immediately start accruing unlawful presence. And if you exceed 180 days of unlawful presence, you will be barred from 3 years. So definitely keep that clock in the back of your head. If your I-94 has not expired, there may be an option, if you're still within the 60-day grace period, to stay in the country and refile the extension or refile the transfer or file a new transfer. Definitely do that in premium processing so that you can get the result. Make sure you get the new I-94 card. If you don't, you need to exit, get the visa stamped, and come back.
One interesting question that came from Nishant Tiku from Facebook is that, can a H-4 dependent work as a volunteer at a non-profit organization like a schools, etc., if they are not expecting any job there, and if it's just a purely volunteer job, not expecting any job, especially for the non-profit organizations though, it is fine. If you're expecting a future job at that particular organization, then it's not fine, especially if you're a mom and you want to go as a parent assistant or parent director of the school, where you take some responsibilities of collecting the money and distributing the money to the teachers or whatever those things are. That is not a full, you never expect to get a job there. So being a class mom or something like that, you don't, there's never a job like class mom. Yeah, there is a job like teacher, but there's never a job like class mom. It's always a volunteer. There's nothing wrong to be a class mom at all. I mean, there's nothing wrong. There are a lot of different voluntary things. My wife used to do it. I used to do it. I used to go read the books to the kids, and of course Emily does it too. That's perfectly allowed. Yes, Emily used to work as a school teacher too. That's different. If you're working as a teacher or anything where you are going to work in a working position, so that may not be allowed. But purely a volunteer jobs which never materialize to a full-time jobs are perfectly fine to work.
All right, Vanil from Facebook has his current H1 and H4 expiring in September of this year, and the visa is stamped. Planning to file his renewal very early, so that's good. But wants to know, once the H1 and H4 renewal are filed, can he travel and come back using the current visa before it expires? The answer is yes, you can. While your extension is pending, you can go out and come back in as long as you're with the same employer. However, what's going to happen is an I-94 number issue. So when your company files your H1 and H4 extension, they're going to list your I-94 number as it is right now on your last approval notice or from your last entry. That is the number that's going to come on your approval notice for your extensions. However, if you go out and come back in between, the port of entry is going to give you a new I-94 number when you enter. And so you're going to have a mismatch between the number that CBP gave you and the number that's going to end up on your approval. That can cause sometimes issues with driver's license renewals. Sometimes it's in that save system. It can be cleared up if you travel one more time after you get the approval, or you can wait outside the country until you get the H1 and H4 extensions approved and then come back. Either of those would be fine.
Ashwin has this question. He is going for H-1B stamping. He's expected to come back from Abu Dhabi Airport. What are the documents to be presented there? One thing I would advise the clients right now is just avoid Abu Dhabi Airport, guys. Please avoid Abu Dhabi Airport. There are too many reports of bad things going on, especially for the Indian nationals coming from Abu Dhabi Airport. I would recommend that you avoid the Abu Dhabi Airport. Another question, even if you're coming from anywhere, you don't have to present any documents. You got the H-1B stamping. Don't present any extra documents. Just present the passport and the H-1B approval. That's all if they ask. If they ask any more documents, then it's different. You have to present. If you present more documents when they don't ask, the officer will get confused and maybe sending you to the secondary though. If they don't ask, just the H-1B stamping, passport, of course that's there in the H-1B stamping, is the passport, and the H-1B approval, that's all.
Pradeep from Facebook has an approved I-140 under a particular project with Company A, and that same project was taken over by Company B, and he wants to know if he needs to refile the I-140. So the I-140 petition and the labor certification are not filed for a project. They're filed for a permanent position that you are going to move into when you obtain your green card, or you might be in that position now, but it's not based on a particular project. It's based on the job. So if the job has changed that your Company A was offering you, and it's a material change, yes, a new labor certification or an amended I-140 might be necessary. But if it's the same job, but you're now working on a different project, that's a different story. And it also depends on the location of the employment. If you have now moved from location A to location B, but your perm labor certification advertisements were all done based on location A, that can be a problem as well. So just not enough information there, but just understand that the green card process is based on a permanent offer of employment that is an offer for a particular position, not a particular project.
This one I need your attention, Emily. Chaitra Adari from YouTube has this question that there is a lot of rumor flying around on the H-1B quota application this year. Because it's only $10, there'll be a lot more significant amount of people filing this. What do you see?
Yeah, I 100% agree with that. You have two things that I think are going to increase the number of filings. Number one is the ease of filing, the $10, and all you need is your passport number, birth date, name, and whether you're filing in the bachelor's or master's cap. That's going to increase the number that are entering the lottery. And you also have extremely low unemployment in the United States, which generally in those years we've seen a much higher number of submissions in the H-1B lottery. So both of those combined, I haven't come up with my prediction for this year, but it's definitely going to be more than next year.
We also expect, Chaitra, that a lot of fraud is going to occur. There'll be a lot of criminal prosecutions of the employers, and in some cases the employees who cooperated with these employers also criminal prosecuted. Our law firm, we get a lot of cases from companies that go overboard and file the cases, not from our law firm, but they do file it without noticing what the criminal implications are. We have noticed that a lot of the H-1Bs that got approved between 2016 and 2018 that were filed in the in-house projects are now, which were approved at that point of time, now are getting revoked. Reddy Neumann PC has commented very aggressively on this one, that they should have a little bit more control over the restriction on who is filing the H-1Bs, though, asking more information, at least the end client information or so, because this is going to increase the fraud and this is going to affect the individuals who are genuinely filing this application. This administration has a tendency of not eliminating the fraud initially. They want more people to come in and trap them, and once they trap them, they want to throw out of the country. Remember what happened in the University of Farmington. And a lot of other things. What they're doing is that they're not trying to eliminate the fraud. They're encouraging immigrants to do more bad activities. So they make it very easy to do the bad activities, so then they can throw them outside the country. So I want everybody who's listening to this to be very careful. Do not file duplicate applications at all. If you were to file a duplicate application, check with a lawyer. I have never approved anybody to file a duplicate application. You know, if you have a Harvard or Yale degree and then you're a Stanford graduate from a software thing and then you are one of the top guy sought by Microsoft, Google, and Facebook, yeah, maybe you can consider. But otherwise, and that too after getting that advice, otherwise don't go with these agencies, especially where you're not working for the company, don't file it. They are going to file it because they know that if you get selected in the lottery, you will pay them the money. That's the reason they are going to encourage you. Don't go with these companies. These companies, they disappear. Every 2-3 years, they come up, they put a name, they disappear. It's you who are going to be in trouble. Even if your H-1B is approved, you're going to be in trouble. Because the USCIS, what they're doing with these fraudulent H-1Bs is that they approve those H-1Bs, and then what they will do is that they will revoke it. And they don't report that to the Congress. They go and say that, oh, well, you know, Congress told us to approve 65,000 H-1Bs plus 20,000. We did approved, but they don't report these fraudulent activities. So we strongly recommend to stay away from those duplicate things. And if there is anything, companies that are asking, and oh, even if you're not there, come file with us and all those things, report them. There is a fraud detection unit in the USCIS and ICE. You can report it. You can go to RN Law Group. You can search in the news section. There is an email address where you can send a report about these companies. That's going to be very good for you guys because it's going to eliminate a lot of this fraud. Send an email to them and send a notice to them.
Yeah, definitely. If it sounds too good to be true, don't even consider it. I mean, I'm even hearing about employers who are offering somehow to be able to file for someone in both the bachelor's and master's cap at the same time, which isn't even an option. I don't know how they're even promising that, but they're making these promises that are not legal, and you know, people are being tempted because they think they're going to get a better chance in the lottery, but it is just not worth it. Please stay away from those. Sindhuja from YouTube is currently on H1, but prior to that she had an H4 with an EAD, and that EAD is not yet expired. She's planning on switching back to H4 by traveling and re-entering, and wants to know, can she go back and use that old EAD? So there's no specific guidance on this that I have found from USCIS or the Department of Homeland Security. What I have found is that an EAD remains valid until it expires or it's revoked. So USCIS would actually have to go back and revoke your EAD for it to not be valid anymore. So based on our research into this topic, I believe your EAD is still valid, and if you're entering an H4, you should be able to use that EAD.
The question about the high salary from Srinivas Aladi about list comply by a credible professional organization for top earners. I would recommend that you either contact Rebecca Chen in our office or Emily Neumann. These are good in our organization for you to contact about the issue that you have.
Prashant from Facebook wants to know, what's the RFE response time for the Vermont Service Center? It's generally 60 days after you submit the RFE. Unless it's premium processing, then it is 15 calendar days. From time to time, they do go beyond that. Once it's beyond the 60-day mark, the employer can follow up with USCIS, or their attorney can follow up with USCIS, either through an e-request or by calling customer service. But 60 days is pretty standard still.
Sandeep from YouTube has this question with regards to the startup company. What are the probabilities of their PERM and I-140 approval? They've never filed a PERM of I-140 approval. Sandeep, actually, the smaller the company is, the better the chances for the PERM and I-140. That's a little bit different. As far as the income is concerned, if you're making enough salary that is required for the labor certification, your chances are very higher in getting a PERM and I-140 with a smaller company. Now, when it comes to the H-1B, Sandeep, though, it is a different story. The bigger the company, the better it is. But when it comes to the PERM, is a smaller company, and you may ask me why smaller company is better. Because to do the labor certification process, there are a lot of different steps that the employer has to act in a proper timing, in a proper fashion. The immigration lawyer coordination with the smaller companies would be much easier, and at times when it requires, to have employee, go to the CEO or any of the HR person to get these things expedited, it's easier with a smaller company than that of the bigger company. So we have noticed that more good approval ratings in a smaller company rather than bigger company. in labor and I-140 only.
Shubnakar from Facebook wants to know if I can use a previously approved H-1B, which was not stamped and never used, to apply for a new H-1B now as CAP exempt. Unfortunately, it's clear that if the H-1B was originally approved for consular processing and you never obtained the visa stamp, you're not actually considered counted in the CAP and still have to be subject to the CAP and go through the lottery.
Kani Adi from Facebook has this question. How do you obtain I-140 document? It says that they may contact you once you file the application. Oh, it's so easy to get an I-140. You can type in Google Freedom of Information Act, FOIA, USCIS. You can file an online application. The reason why they list it out that they may contact you, which we have never seen them contacting, when you file an online application is, they want to confirm, is it you? Because you're filing all this application online. Is it somebody else who is filing on your behalf? I mean, I'm not speaking of lawyers filing on the behalf, but a fraudulent guy who has all your information, what if he's filing on your behalf and getting the information, giving a different email address? That's all the USCIS is concerned. But if you file an application, they're not going to contact the employer. Even if they contact you, they're just trying to identify, are you the proper person who is entitled for the information of the I-140? Never had I seen any problem with anybody on this.
Sudarshan from YouTube has a good question. His OPT extension ends on April 3rd, 2020. This is the end of the STEM extension. So if his application is selected in the lottery, he wants to know how he will be able to work after April 3rd, 2020. So this goes back to what we were talking about at the very beginning of today's video. Super important. You are going to find out whether you were selected or not by March 31st. Your employer must get your H-1B petition filed at USCIS, received to USCIS by April 3rd. If they timely file by April 3rd, requesting a change of status with an October 1st start date, that will make you eligible for the CAP gap, and you'll be able to continue working all the way through September 30th based on that filed application. If your employer files 1 day late on April 4th, even though they have till June 30th to file, if they file on April 4th, you lose your CAP gap. You have to stop working April 3rd and cannot start again until October 1st, assuming that your H-1B is approved. That's very important to be aware of.
Anju Thomas is an L2 EAD. She's now moving to H4. She's looking for postdoctoral position. Which is better for transition, J1 or H-1B? Well, assuming that most of the postdoctoral positions are for nonprofit and higher education institutions, you are exempt from the H-1B number, most probably, yes. I would choose H-1B over J1 visas, Anju, because J1 sometimes has the 2 years home residency requirement. There are certain other obligations for the J1. H-1B is more easier, especially for the work purposes, more flexible as compared to the J1 though.
For YouTube, from YouTube, wants to know if for the 221G administrative processing, would USCIS contact you, the visa applicant, to get some information about previous employers, or would they contact those employers directly? How does the process in general work? So typically for a 221G, it's very rare for the consulate to contact you if they need additional information. They're usually either, if they're contacting anyone, they're contacting your employer to verify that the job is available, that they have the employer-employee relationship, and that all of the documents submitted were proper, valid documents. They sometimes will reach out to the end client if you are working in a third-party placement situation to verify the validity of the letters that were signed by the end client. They may reach out to past employers through their fraud detection unit, especially to verify experience letters that have been submitted. I don't see that a whole lot necessarily with companies in the US, but if you're using experience from your employer outside the US, there is absolutely a fraud detection unit that goes and verifies the validity of those letters and that that company did actually exist. but it's pretty rare for them to contact you because you've already been interviewed by them, so you've already given them the information they need. Now they're going and digging into the background to contact others. Sometimes they don't contact anyone at all. It's just going through the process of additional security checks and verifying rather than actually reaching out to people for additional information.
Avinash has this question: is there a premium processing for H4 EAD filed along with the H-1B extension premium? Unfortunately, Avinash, there is no premium processing for H4 or EAD that was filed along with the H-1B. We at Reddy Neumann PC, every other week, we take approximately 50 to 60 people to the court and we get it approved within a short period of time. Normally within 2 months from the time we file the application. There are some cases that have taken longer than 60 days, but mostly within 60 days, where we get the H4 plus EAD approval. You have to go to the court system. Reddy Neumann PC collects all the people together. Every 2 weeks, we take the people to the court and get those things. That's the only way to expedite the H4 EAD process. The premium processing doesn't exist. The expedited processing never, 99% of the time, don't work at all.
Sundeep from YouTube wants to know what things should he consider if he's planning to join a startup company regarding the green card filing.
I already addressed.
Oh, you already did that one?
Yes.
Sorry.
One question that came is that Vijay Prakash from YouTube is on EAD. It's been a year since he filed an adjustment of status based on the employment based. Can he change the employer? The answer is yes, Vijay. You can. But when you change the employer, the new employer must file a called AC-21, also called as 485J supplement. The next job that you are going to be joining should be similar to the job that you're doing. So if you're working as a software developer, you are moving to another software job, that's perfectly fine. But if you're moving from software engineer to a mechanical engineer, that may not be fine. A little bit software changes won't make much difference. You're fine in changing. So when you move from company A to company B needs to file a 485J supplement, and that will complete the transition from company A to company B. Even if company A afterwards withdraws the I-140 or anything, nothing will happen. Your green card will go through smoothly.
Morale from Facebook wants to know if we need to present the original I-797 approval notice during the visa interview or at the port of entry. What if you lost the original? So the consulates nowadays are able to verify the approval information in their PIMS system. So they usually will accept a copy of the I-797 approval notice. Same thing at the port of entry. If you're coming with a copy, they may send you into secondary inspection while they validate that it is a valid approval notice. But you should be able to at least travel with the copy.
I just want to add, we haven't seen any problem in the past 3-4 years for the people who don't have the original H-1B approval. That used to be a problem like 15-16 years ago, but we haven't seen anybody in trouble for that reason.
Arun Kumar from Facebook. His wife is currently on H4 with an H4 EAD. Her H-1B was selected in the lottery, I'm guessing last year, and it's still pending. The case still shows case was received. Is it normal? Should we switch to premium processing? Oh my goodness, please upgrade to premium processing and get it over with. There are a few straggler cases, but there's zero reason for your case to be straggling at this point because premium processing has been available for months. Get it over with, especially get the answer now, because if it's a denial, you want to know before March 1st so that you can potentially submit a registration this year in the CAP. If you wait on that one and then on April 3rd you end up with a denial and didn't submit a registration this year, you have no option of filing an H-1B this year.
Chetan is trying to move back from India to United States, and can he use the priority date that he had back in olden times to right now when he's to port the dates into EB1 or EB2? Chetan, the answer is yes, absolutely you can. However, there must be two conditions that must have met. The I-140 must not have been withdrawn after it's been approved for more than 180 days. That's number one condition. Number two condition is that the I-140 must not have been withdrawn until January 17th of 2017. If it's withdrawn afterwards, it's fine, but if it's withdrawn before, you cannot do it. You cannot use that. The best way to find that, Chetan, is you can file a Freedom of Information, FOIA-USCIS. You can file it online and they will give you an I-140 petition. You will be able to determine whether or not the I-140 has been withdrawn or not. You need that for all purposes. Even if your employer says, your previous employer says he did not withdraw, I still want you to go and get it. It's free, and I don't recommend you to go through a lawyer. You can just file for yourself and get it. That will get you secure, where if the I-140 has been withdrawn within 180 days, if it's not, it's not withdrawn until after January 17th of 2017. Once you have that in your hand, then you can go to any lawyer, you can show the I-140 petition, and he'll be very comfortable using that one.
Never Say Never from YouTube has a question along those same lines. He has an approved I-140 with company A, moved to company B, and has not filed the green card process yet with company B. He wants to know what will happen. Will he be able to extend his H-1B again after he's transferred to this company? So again, assuming that your approved I-140 with company A was approved for at least 180 days before it was withdrawn, or it has not been withdrawn yet, and hasn't been withdrawn before January 17th, 2017, you can actually continue to use the old employer's approved I-140 to continue extending your H-1B with any other company. Even if company B still hasn't started the green card process, that's totally fine. So as long as that I-140 remains valid, then you can keep using it to get those extensions.
Savi has this question: is it better to work on a H-4 EAD or a GC EAD? If you do have both EADs, yeah, I would use the H-4 EAD to work on. There are some advantages using the H-4 EAD. If you have both, yeah, I would use the H-4 EAD. That would be the best thing to do.
Ravi from YouTube has his STEM OPT EAD valid until July, but his H-1B and I-94 recently got approved only till January. Which date takes priority? Really good question. Unfortunately, it's January 2020. So the most recently issued I-94 is the one that's on your H-1B approval notice. That cuts short, assuming that this was a change of status that was approved on your H-1. Your STEM extension is gone. That EAD you can no longer use it. You need to hurry up and file an H-1B renewal before your January 2020 I-94 expires.
This question from Chetan has different answers by different lawyers. I for sure know that. Does he have to maintain H-1B and I-485 EAD? Can he give up his H-1B though? I'm leaning more towards giving the H-1B. I don't see an advantage maintaining the H-1B. There are some situations where if your H-1B extension gets denied, it may actually end up to be a problem in 485. I know some of the lawyers will tell you to keep the H-1B and 485 EAD. I don't do it. Do you?
Yeah, I think it really depends on if the I-140 is already approved by now, and also if there's anything in your background that could cause a 485 denial. We generally know before we file a 485 that there's a risk, and so hopefully your attorney would be able to assess that and determine how risky it is for you to rely solely on that 485 and EAD.
Yeah, if there is some company changes that occurred in the I-140, some problems in the I-140, we do recommend people to maintain the H-1B. There are situations, I would say, that about 5 to 6% of the time, we do tell the people to maintain the H-1B, but mostly we tell you don't have to maintain it.
Akanksha from Facebook wants to know, if I join a company using the H-1B receipt and my previous employer has withdrawn the H-1B, what happens if the transfer gets denied? What are the next steps? So the difficulty is that eliminates your ability to go back to the previous employer since they've withdrawn that approval. It really does depend on whether your I-94 has expired or not. If your I-94 has expired, the denial of the transfer means you're immediately accruing unlawful presence. So you have to be very careful of the 180-day unlawful presence and the 3-year bar. If your I-94 has not expired, maybe you're still in the 60-day grace period where you could potentially refile that transfer or file a transfer to another employer. Most important thing is, because every denial situation is different, there's a lot of factors involved, make sure to talk to an attorney before you make any decision if you're ever in a denial type situation.
Manish has this interesting question. His priority date is October 2018. He's approved in EB1A category. Any chance of filing 485 this year? Manish, don't ask me the question, any chance. I mean, do I have a chance of getting a $230 million lottery? Yes, I do. So what are the probabilities? That's the best question that you should ask for. I think so that this year, for 2018 to be current in EB1A, I would say for Indian nationals, I would say 20%. What do you say, Emily?
For 2018?
2018 October, yeah.
I don't think it'll be current this year.
Okay, well, I say 20%, you say 5%?
I'd say 1%.
1%, okay. I stick on 20% because I don't know, but yeah. So that's my guess, hopefully.
At least if we mean this year as in
Until
till September 30th of this year.
Yeah, okay. Well,
maybe October 1st we'll see some movement. Manu from Facebook wants to know if we can re-enter with the visa stamp that's pertaining to the previous employer. So this comes up in a situation where you have an approval notice with company A, you got that visa stamped, came into the US, and now you filed a transfer to company B. Your visa stamp with company A has not expired, and you have an approval notice with company B that is not expired. You can absolutely use company A's valid visa stamp to go out and come back in to work for company B. It does not matter that company A is listed on that petition. All that matters is that it's the same visa category.
A lot of discussions on Senate 386 bill. No updates yet at this point of time. The Senate 386 and HR 1044 right now seems to be that Senate is busy on something else. So we don't see much action going on in Senate 386 or HR 1044, which was already passed in the House.
Vijay Prakash from YouTube has a question about the Supplement J and wants to know, is the I-485 Supplement J required to submit if you've already completed your green card interview? His employer is telling him it's not needed unless there's a request for evidence or annoyed. I don't think I would agree with that. I think
I would still file the 485 J supplement. Here are the risks that are associated by not filing the 485 J supplement. Because if the USCIS knows that you're not working for that company, they may immediately deny your 485 application. There are ways to revive it. We have done it successfully in some cases. In some of the cases, we are unable to do it, but most of the cases we were. But I would not wait for them to deny the 485 application and try to act on it. I will go file the 485 J supplement. Once the regulations came out in January 17th of 2017, it is now absolutely mandatory to file the 485 J supplement. It may actually also, if you don't have a 485 J supplement, it may even have some problems in the future, which we haven't seen it though, but it may have some future problems because at the time of green card, you are not working for the company which you filed the adjustment of status. And since the new regulations came on January of 2017, you don't have any 485J supplement. It may even create a problem after you get the green card too. So I would be cautious and file the 485J supplement.
Janae from YouTube wants to know, how accurate is the timeline posted on the regulatory agenda, and can we go through what is the whole regulatory process? Great question. That timeline is extremely inaccurate. They go past those dates all the time. I mean, you can just see it with the H-4 EAD. How long has that been on the regulatory agenda?
Well, from past 2 years, we've been telling it's 3 months.
Right.
We're just repeating what's said in the regulatory agenda.
Yeah, so now the regulatory agenda is saying maybe February or spring 2020, but so many times whatever date is in that regulatory agenda gets passed and no proposal happens. Then the next regulatory agenda comes out. They come out spring and fall, and you'll find a new date. Things get delayed all the time. So as far as what is the process, so let's take the upcoming proposal that we're supposed to see for changing the definition of specialty occupation for H-1B employer, H-1Bs, for example. So the regulatory agenda tells us that fall of 2020, the Department of Homeland Security expects to propose a regulation that will modify the definition of specialty occupation. So fall 2020 rolls around, and let's say that we're actually going to follow this timeline. First thing the Department of Homeland Security has to do is write out the proposal and give it to the Office of Management and Budget. That office is responsible for taking a look at all of the different regulations all of the government agencies are planning to do, and making sure there's nothing conflicting with what another agency is doing, making sure it's in line with any presidential executive orders and all of that. So first thing is OMB review. You can follow along with it on the regulatory agenda website. It'll tell you when it's been submitted to the OMB. Then there'll be an update saying it's cleared the OMB. Once it clears OMB, the agency has to then publish the proposed regulation in the Federal Register. Once that happens, they will then announce specific days when you can comment on the proposed regulation. Usually a 60-day commenting period is kind of the standard. So you would go on that regulations.gov website. You can submit, anyone in the public can submit their comments for or against, explaining things that should be fixed or modified. Comment period closes. Homeland Security goes back, takes all of those comments, reviews them all, pretty much has to put them together and organize them into different groups and explain why they're doing things one way and not a different way, why they disagree with the commenter, why they agree with the commenters, come up with a final rule, submit that final rule back to the OMB again, where they're going to review it again. OMB gives their approval, then it goes to publishing the final rule in the Federal Register, which usually has a effective date maybe 60 days in the future. So that is the regulatory process in a nutshell. As you can see, there's many steps to it. It takes a long time, doesn't happen overnight. Generally 6 months is probably the minimum you can expect any kind of regulation to come out. Most of the time it takes much longer than that.
Akhil has this interesting thing. He voluntarily left United States because he went to the Farmington University and he got an email from, he said Indian Embassy, but I'm assuming that he got an email from US Embassy that his visa has been revoked. If he files a H-1B, what are the probabilities for him to get the visa stamping? Akhil, I want you to consult a lawyer immediately. What we're noticing is that the Farmington has recorded at least a lot of people on their phone calls. People tell something, and then what happens is that in the intent to revoke and certain other things, we are noticing that there is a conversation between the University of Farmington student and the ICE agent. There is a recording, and they give the transcript of the recording. That tells a little bit different though. So I would want you to note down every conversation that you may have had it before, after, while, and while you were going to the University of Farmington. Even if you made an inquiry at the University of Farmington, I want you to make a note of those things and contact an immigration lawyer though. I would say that your chances may be absolutely not bright at all.
Yeah. We've seen a lot of people get into trouble with Farmington.
So there are some cases where we noticed this was in March of 2019 or somewhere in April of 2019. They even got their visas. One person got a H-1B stamped in U.S. consulate in Canada. One person got a H-4 stamped. When they were trying to come into United States, they were denied entry into United States. There are particular sections in the DS 160 that asks about whether or not you violated the legal status. That's one question. The second thing was that, have you ever misrepresented in obtaining the immigration benefits? And that's where the major thing is coming. Have you ever misrepresented in obtaining the immigration benefits? That's what they are alleging in the Farmington, is that you got the CPT, by misrepresenting that you're going to school. And that is a misrepresentation, and now you're barred forever coming into the United States unless you file for a waiver and get the waiver approved. That is the contention where the USCIS and the CBP is right now. So I do not want you to make any attempt to come into the United States without consulting with a lawyer.
All right, I think it's about time to wrap it up for today. Thank you so much for joining us. If we didn't get to your question, please know that we do have a conference call that's free that we do every single day where we basically do the same thing. People call in and ask their questions. You can get the schedule and the dial-in number for that by going to rnlawgroup.com. We're also on Facebook, Twitter. You can follow us pretty much anywhere on social media these days.
And please leave comments how we can improve better in our presentation, not in the question and answers, but after the event is over in the YouTube and Facebook, how better we can improve our presentation that will make answer better and serve you better. We really like your comments that you pass, and we can improve on those things. Thank you for logging in, guys.